Good afternoon, Your Honors. The matter before the court today is the case entitled State v. Sartwell, case number 25 AP 059. Representing the appellant, Ryan Sartwell, is AJ Rubin. Representing the appellee, State of Vermont, is Travis Weaver.
Okay, thank you very much. Good afternoon, everybody. We'll hear from counsel for appellant first, of course. Please, excuse me, please introduce yourself, identify your client, and then proceed.
Thank you. May it please the court. My name is AJ Rubin. I'm an attorney representing Ryan Sartwell. Mr. Sartwell was held without bail by order of the Windsor County Criminal Court earlier this winter, and we have filed this appeal requesting that the court review the hold without bail order. We have not contested the aspect of the hold without bail order that involves the evidence being great, evidence of guilt being great. However, I understand that the court has reviewed the documents and hopefully the transcript as well, and understands that part of the discretion to be used, we are asserting, relates to the fact that Mr. Sartwell was convicted of his first felony when he was 16 years old, and that the other felonies are over a decade old. And he's a lifelong Vermonter.
Mr. Rubin, those are the enhancement, the ones to use to get the life offense here is the habitual, correct?
That's correct.
And none of the current charges against your client involve a life sentence. The life sentence component is on the enhancement.
That's correct. There are 3 felonies in our docket, Justice Cohen, and the state has elected to try to enhance all 3 of them based on 3 prior felonies, one of which happened more than 2 decades ago when my client was a child.
It was 16, 18, and what, 27 was the ages of your client?
He was 16 when he was convicted of the first felony, and that he was actually 15 apparently when he committed that felony. The second felony was in 2007, and the third felony was in 2011, more than 10 years ago.
And so if he committed that offense when he was 15 today, would that be a felony, or would that be in the juvenile docket?
That would be in the juvenile docket, Your Honor, and we are still still trying to get copies of the change of plea colloquy and those documents, but that we were not able to contest that felony occurred, that it was on his record, but we may be in the course of the actual trial trying to dispose of that based on it not being a valid conviction. But indeed, had he committed those offenses today, they would not be felonies in the adult court.
Thank you.
So I bring that up, Your Honors, because we think it is relevant to the discretion of holding him without bail, that, as I said during the oral argument, the argument in front of the trial court judge, it's just unlikely and unreasonable to think that anybody would sentence Mr. Sartwell to life in prison, given the offenses he's currently charged with, which are mostly property offenses involving alleged drunk driving or drug driving, drunk or drug driving, and basically aggressive behavior when he was arrested. And so we think that goes to the discretion. The two, I filed an amended appeal brief, Justices, because I neglected to make the statement of the issues correct on the second page. And so, to be clear, the statement of the issues that we're arguing today are that the trial court failed to identify weighing the possibility of cash bail or surety in this case, and that the trial court abused its discretion when not considering the 2 proffered custodians who were at the hearing as acceptable custodians. Together, we believe that both of those issues to be resolved today by this court should weigh in favor of remanding the case and requiring that some cash bail and some conditions of release be imposed, and that Mr. Sartwell not be held without bail.
But not the validity, Mr. Rubin, not the validity of the conviction that occurred when he was 16. That's not part of this appeal.
It is not part of this appeal, but this is a de novo appeal, and so if the court wants to take that up and issue a ruling about that, I would not, would not object to that. But we did not brief that, and I don't have information about that to argue. I did look at State versus Rideout that appeared to indicate that the courts can use convictions when someone is a juvenile if it is a felony conviction. So we are still working on the legal theories about trying to get rid of that earlier felony.
Okay, thank you.
Regarding the first issue, Your Honor, is about cash bail. As I noted on page 9 of the amended brief, we believe that the trial court was required to determine whether or not imposing cash bail or surety bail and conditions of release together would have been adequate to assure public safety and Mr. Sartwell's return to court. We cited a few cases there of Gustav and Waterman, and I think a review of the transcript and a review of the court's order in this matter will demonstrate that the court did not identify why it failed to consider cash bail or surety as part of the toolbox for which to avoid the very detrimental pretrial incarceration without bail. It was clear to the court that Mr. Sartwell was a public defender client, that he was a needy person because the court had appointed a public defender. The court noted in its decision that Mr. Sartwell was being held in a different county on, I think, $10,000 bail. So it understood that that was a possibility. But the court's order in this matter is devoid of any discussion about why significant cash bail would not have been adequate in combination with other conditions of release to allow Mr. Sartwell to defend himself while not incarcerated. We believe that the State versus Waterman, which is cited, is on point and indicating that if the trial court failed to identify its rationale for why a certain condition, in this case cash bail or surety, was not going to be sufficient, the failure to even discuss that in the order is sufficient for this court to find that there was an abuse of discretion and that it should be remanded for a discussion about that. We all, I think, understand that significant cash bail being posted by someone who is already identified as a needy person is a very strong motivation for that person to come back to court when they're supposed to.
So Mr. Ruman, this is sort of a hypothetical question, and if you don't wish to answer it, that's fine. But if the trial court were to say, okay, I'm going to impose cash bail, and puts a very high number on it for a needy person, an unachievable number, would that be the same as a hold without bail? Say like $1 million on this type of case.
So it could be if it was $1 million, Justice Cohen. That is a hypothetical question. It's not out of the realm of possibility that a needy person may have acquaintances in the community who would be willing to put up a house or something like that. Certainly, bail that is completely unattainable, would be contrary to the statutory architecture of cash bail. But the lack of any discussion about that and the lack of any option for $10,000. I mean, the court noticed that there was a $10,000 bail in a different county, which Mr. Sartwell was really unable to access because it wouldn't make a difference given the fact that he's being held without bail here. So it is sort of a hypothetical situation, Justice Cohen. However, even if a high bail, maybe slightly less than $1 million,
I was just using that number to say, like, okay, I mean, it could almost be the same thing. Hold without bail under the life offense versus $1 million on unachievable bail.
And if that were the case, I may be here arguing that unachievable bail is so high that it's not possible. So I only have 1 minute left. I just want to skip to the second part, which is the fact that under State versus Casanel, the court really abused its discretion by not discussing the fact that Ms. Wells and her mother, who were both in court, which the transcript demonstrates, were available to supervise, agreed they would supervise, and would also agree they would call the police should Mr. Sartwell fail to comply with conditions. We believe State v. Castanel is really the on-point case here, in that the trial court did not identify those factors in its decision. It simply said that because Ms. Wells had, in the court's opinion, it was not very close to Mr. Sartwell, even though she had known him for over a decade, knew about his wife dying prior to this incident that occurred in 2023, that by itself was sufficient for the court to find that Ms. Wells was not an appropriate custodian. The court failed to mention the fact that her mother was in court, which the transcript of the hearing demonstrates, and that both women had agreed that they would supervise Mr. Sartwell and call the police should he violate conditions. So we also believe that that was an abuse of discretion for failing to include that in the court's order, and basically requiring that the custodian be absolutely perfect and more than what was required in Castanel. I'm going to stop now.
Okay. Thank you very much. We'll hear from counsel for the appellee. Please do the same. Introduce yourself, identify your client, and then proceed.
Thank you, Your Honor. May it please the court. My name is Travis Weaver. I'm a deputy state's attorney in White River Junction, Vermont. I represent the state of Vermont in this case. I guess I want to start by just returning to the issue about the age of Mr. Sartwell at the time of his predicate offenses, because I actually don't disagree with the appellant and the fact that that was an appropriate issue for the court to consider, and it was an appropriate argument to make. And certainly charging someone as a habitual offender and seeking a hold without bail order is a serious thing for the state to have done. I would argue the state, even at the time of the original offense, had reason to do so. And the reasons to use its discretion in how we charged the case and asking for that order have only grown greater since this case first began. The fact of the matter is Mr. Sartwell is a very serious risk of flight. He fled from the police during the initial incident. He broke his shackles back at the police station. He fought with the police on 2 separate occasions. While waiting for his initial hearings, he was captured by a DOC officer saying that if he could make bail, he would run away. I think that's a very significant fact to keep in mind when the court decides whether or not bail would in any circumstance be appropriate to assure his future appearance, given that he said early on, if he could bail out, he would run away. Subsequently, he was accidentally released by the sheriff's department based on a miscommunication with the trial court, and he did run away. He was gone for about a year, during which time he picked up additional felony charges in 2 other counties.
That's not a risk of flight, Mr. Weaver. I mean, that was a mistake from DOC or a mistake from the court that he got out. I mean, is he expected to? I mean, he was released. Is he expected to go see if it was valid or not valid? Does he have a duty to do that? Or?
Well, I think that, as Judge Gray noted, because the original hearings had been conducted by Judge Treadwell, in those initial proceedings, he was very direct with Mr. Sartwell that he was being held without bail. And I'm not saying no, I don't think he should have had to stay in the courthouse necessarily if he'd been let go, but certainly for an entire year to go by when the defense attorney for him doesn't know where he is, the court doesn't know where he is, he's on an arrest warrant status, he certainly knows he's facing serious felony charges. And I'd also indicate that in one of the affidavits where he picked up charges, I believe it was in Washington, it could have been the Wyndham matter, he again fled from the police. So I guess I can imagine a world in which there is some innocent ambiguity, is like, oh, I didn't know I ever had to come back to court again. But given that he voiced an intent to flee and run away and then proceeded to do so, I think colors that.
But it's different than an active escape. I mean, if he actively escapes,
yes,
he'd be, that's one thing, but it's an administrative mistake and he gets out. And he's like, okay, why would he, under any circumstance, would he question? He wanted to be out and he thought he was out validly.
I just don't see how you can take that to mean that you don't ever have to go back to court again or check in with anybody. People are given a condition 1 and 2. They are expected to advise the court of where they are, of who their attorney is, to keep in contact. I think that's a very minimum expectation of defendants. He did no such thing. I think based on his conduct, any innocent explanation to his actions just simply doesn't carry water, especially when he's picking up additional charges in other counties, and continuing to flee from police. All of that is to say, that is an argument that the defense can and did make to the trial court judge. The trial court judge considered a lot of these factors, considered the fact that he was facing multiple felonies, considered the fact that he voiced an intent to run away, especially in light of the fact that he said, if we can get the bail bondsman, I can get out of here and I can just run away. And then they also considered everything else that Attorney Rubin indicated. They considered the proposed Rule 4 people. I would just simply say that it's not entirely clear from the record if it was a serious intent of the defense at the time to propose both as Rule 4 custodians. Those passing reference to the mother, I'm not even sure I know her name. She did not testify at the hearing. The focus was clearly on the Rule 4 person who testified, and even then, there was very little information provided to the court about how she could be an effective Rule 4 person given his history. I would pause to note that even if the court did find that she was an appropriate Rule 4 person, that would not have been dispositive either. The court could have still weighed whether or not even an appropriate or potentially very effective Rule 4 person would be sufficient to meet the presumption against being incarcerated given his history of flight.
So, Mr. Weaver, regarding Mr. Rubin's argument that the likelihood of the state requesting a life sentence with these types of pending charges using the 16-year-old and 2007 enhancements to be fairly slim, should that be part of the evaluation in any way?
I think based on this court's guidance and how expansive the discretion is that it is traditionally conveyed upon trial courts, I don't see that there's anything that's not appropriate to at least be considered. This court has frequently said that the trial courts have broad discretion, and as long as their discretion is not exercised arbitrarily, that their decisions will be sustained. So if a trial court were to say, you know, this is a matter, and I've actually seen trial courts.
I just want to make sure we still have the chief. I'm sorry. I'm not seeing him. Justice Waples, I know, was intentionally off camera. Yeah, but Chief, are you there? Ariel, can you just stop the time for a second while we...
Chief, are you on?
The chief just messaged me. He's having connectivity problems.
Okay.
You want me?
Yeah, I'm back. I'm back now. But Justice Cohen, will you continue to run the hearing instead of me, please?
Sure. Chief, do you remember the last thing that Mr. Weaver said? He was I asked him a question regarding the predicate offenses, and did you hear that? Mr. Weaver, why don't you go ahead and finish your argument, and we'll get this. This is all being recorded as well, so we can play it back for the chief if necessary. So why don't you go ahead and finish your argument?
Thank you. May I just ask the clerks how much time I have left, given that we paused?
Sure. We'll give you an extra minute for the situation here.
At the moment, you have 4 minutes remaining, and I paused the clock when Petra popped up.
Oh, you did? Okay.
Thank you. I was saying that trial courts can and have faulted the state for being over aggressive with charging decisions, whether that can be the nature of the charges themselves or even the use of a habitual offender. And again, I think we would be in a different situation. This case took more than a year to even get to a hearing on the weight of the evidence, a weight of the evidence hearing, in part because it was difficult to get Mr. Sartwell to return to court for that period of time after his accidental release. Had he come in the first couple of weeks and we'd scheduled a prompt way to the evidence hearing and the defense attorney had made all the arguments he's making now, I still think the state could have pointed to his expressed intent to flee as a significant reason for the court to exercise its discretion and hold Mr. Sartwell without bail. Of course, the court could have also considered that, look, we're not looking at a serious life sentence here. I know normally under our case law, that part of the rationale is that the life offense is a proxy for risk of flight, and that's in part of the court's consideration, but the court would have discretion in a particular case to say that has less bearing here. Again, from a legal standpoint, we meet the legal predicates of 7553. It would still be part of the court's assessment and analysis. And again, given his history of having fled and the fact that the court in their order did lay out this history that I'm talking about now, none of these reasons are absent from the court's opinion. A significant part of the defense's appeal is that she didn't sufficiently explain her rationale. She went into the details
If we were to remand this back to the trial court for the determination of appropriate cash bail, would that have to be, under current Vermont law, would that have to be achievable cash bail?
It would not necessarily, Your Honor, but I do think there's sort of thinking about that if the only effective bail can be a hold without, then why pretend you're doing this under a bail analysis where a hold without is legally viable in the court's discretion. I don't think there's any amount of bail given his risk of, or his expressed intent to flee, that if he could make it, there's any reason to believe that he would return to court. I believe if he makes bail, we're not going to see him again, or at least it's going to be another couple of years as he continues to hide out in the woods. So, but ultimately, Your Honor, I believe the court had the discretion to consider everything that we're now discussing. I don't think anything the defense has argued would have been an inappropriate thing for the court to consider. But ultimately, under the law, they had the burden of proving that he was bailable. They presented very little evidence about the effectiveness of the Rule 4 person. She had an intermittent relationship. She hadn't even really restored contact with him, she testified, until basically after he got out with the pending charges. And then again, given his intent, his expressed intent to flee, one has to ask just what could she physically do to make sure he returned to court? If he's willing to fight off police officers and flee from them into the woods, it's very difficult to imagine how a middle-aged woman can promise that he will return to court. So with that, I will forfeit the remainder of my time. Thank you.
And Ms. Murphy, does the appellant have any additional time left?
Appellant has no time remaining.
All right, could you call the end of the case, please?